Have you ever stopped to think about how a brand like Coca-Cola is, well, everywhere? You can find it in almost any country on Earth. But here's the crazy part. The laws that actually protect that famous logo, they stop dead at each and every border. And that's the puzzle we're going to unpack today. How do global brands even exist in a world full of national laws?
Right? It seems like it should be a simple question, but the answer is anything but. You'd think, hey, a trademark is a trademark, but for most of history, that just wasn't true. A logo you registered in one country was basically meaningless in the country right next door. So how on earth did anyone build a global business on such shaky legal ground? The heart of this whole problem comes down to one really important legal idea: territoriality. It's a simple concept, but it has massive consequences. It means that a country's laws stop at its borders, period. So your trademark right is limited to the territory of the granting country. Your French trademark? It's just a piece of paper in Germany. This one principle is the fundamental wall that international law has been trying to break down for more than 100 years. Okay, here's a great way to visualize this. Think of trademark laws like electrical outlets. For the longest time, every single country had its own unique system, its own weirdly shaped plug. So if you wanted to plug in your brand and sell your products, you needed a totally different legal setup for every single market. I mean, can you imagine the logistical nightmare? So you've got this total legal chaos. What do? Well, the international community came up with its first big idea for a fix. They called it harmonization. And the idea was pretty straightforward. Hey, what if we all just agree to make our laws, more similar? And this is a really great way to see the two main ways people tried to solve this. On the left, you've got harmonization. This is all about convincing countries to change their own laws to look more alike. The goal here is just equivalence, making things roughly the same. But on the right, you have a much more radical idea, a unitary system. This isn't about tweaking national laws at all. It's about creating one single law for a whole bunch of countries. The goal here isn't just similarity, it's total uniformity. But, and this is a huge but, there's a fatal flaw in just harmonizing laws. See, you can get countries to pass laws that use the exact same words, but you can't force their national courts to interpret those words the same way. Every country has its own legal history, its own traditions, so the same phrase can lead to totally different results. At the end of the day, that core problem of territoriality just refuses to die. So let's go back to our electrical outlet analogy. Harmonization is basically like getting every country in the world to agree to make their outlets circular. It's a start, right? They look more similar, but the voltage is different, the prongs don't match, you still need a whole bag full of adapters to get anything done. It simplifies the problem a little, but it doesn't actually solve it.
And this led to more than 100 years of international agreements, each one trying to fix this mess. But as you're about to see, it was kind of like a game of legal whack-a-mole. You'd patch one issue and another one would pop right up somewhere else.
I mean, look at this. It started way back in 1883 with something called the Paris Convention. Then came the Madrid system, which was a huge leap forward in simplifying the paperwork. Over the next century, you get all these updates and new treaties to streamline things even more. But do you see the pattern? Every single one of these was a procedural fix. They made the paperwork easier, sure, but they never ever got rid of the fundamental need for separate legal rights in every single country.
But then, something different started happening in Europe. See, the goal there wasn't just to make trade a little easier. It was to create a true single market. And for that to happen, a messy collection of legal adaptives just wasn't going to cut it. They needed a real breakthrough. And what they came up with was this brilliant two-step plan. First, back in 1988, they passed the Trademark Directive. This was harmonization on steroids. It forced every member country to rewrite its national laws to match a common standard. But they knew that was just building the foundation. The real goal, step 2, was to build something totally new right on top of it, a single unitary trademark for the entire European community. So you might be asking, why not just stop at step 1? I mean, deep harmonization sounds pretty good, right? Well, to really understand why it wasn't enough, we need to look at this classic legal battle between two companies, Sabel and Puma. It's a case that perfectly exposed the hidden flaw still lurking in harmonization. Okay, so the EU's new harmonized law had this very specific phrase in it. It said that infringement happens if there's a likelihood of confusion and, this is the key part, that includes the likelihood of association. Seems simple enough, right? Nope. Courts all across Europe started interpreting this one little phrase in completely different ways. The German courts, for example, looked at this through the lens of their own legal traditions. They basically said, look, A simple association, like a customer just thinking, hey, that leaping cat reminds me of the Puma logo, that's not enough. For us, you have to prove that people are genuinely confused about where the product is coming from.
And this is where the genius of the EU's structure really kicked in. The German court referred the question up to the European Court of Justice, the highest court in the EU. The ECJ then acted as the final arbiter, the supreme referee. It issued a single, binding ruling on what that phrase meant for everybody. This moment perfectly shows what harmonization by itself is missing. You need a supreme referee to make sure everyone is actually playing by the same rules.
Okay, so with the Supreme Court in place to act as that referee, the EU could finally take the last, crucial step. It could create a truly new model for how trademark law works. The result was the Community Trademark, or CTM. And this is the game changer. One application to one office gets you one single right that you can enforce across dozens of countries all at once. It was the first time anyone had really solved that one country, one law problem that had been holding back global trade for a century.
So, to bring our analogy all the way home, the EU didn't just get its members to agree on making their outlets look the same. No, it went way further. It essentially built a brand new power grid and created one single, standard outlet for the entire continent. One plug that now works seamlessly across 27 different countries.
So the EU model proves that these regional unitary systems are actually possible. But it does leave us with one last, really big question. Given the enormous political and legal hurdles, could what the EU pulled off for one continent ever be scaled up for the entire planet? Could a truly single, worldwide trademark ever actually exist?